It's 12 o'clock on Tuesday, February the 20th. Tuesday, February the 20th. The House Criminal Justice Subcommittee is now in session. Madam Clerk, please take the roll.
Representatives Davis, Fritz, Gillespie, Hardaway, Howell, Halsey, Johnson, Lamberth, Moody, Russell, Towns, Chairman Doggett.
Present.
Chairman Doggett, you have a quorum.
Thank you, ma'am. Members, do we have any personal orders before we begin today? Seeing none, we'll go to our Sergeant of Arms, Mr. Tyler Muniz, for his weekly words of wisdom.
Good day, everyone. Welcome to the Capitol. Today's words of wisdom are brought to you by a legendary chairman, Rusty Grills of the 77th District. If you want to get into politics, make sure your fences are good if you got cows at home. Have a great day.
Thank you for that. Representative Fritz.
Thank you, Mr. Chairman. I'm a bit out of order, but I want to recognize Billy Pickle as your Loudoun County Road Superintendent. Appreciate him coming today.
You were not out of order yet. We were still under the personal orders provision, so you're okay. All right, we've got a lengthy calendar, members. It's that time of year, so let's jump right in. Items number 17, House Bill 1848 by Representative Parkinson is rolled 1 week. Item 18, House Bill 1954 by Representative Parkinson, rolled 1 week. Item number 1, House Bill 1819 by Representative Littleton. Wait a minute, time out. 1817, House Bill 1817. You are recognized.
Thank you, Mr. Chairman. And if I could have a personal moment, I have some students from Freed Hardeman, speech pathologist students, and my granddaughter happens to be with them, Gabriel Tipper. So if we could please make them welcome. I love it when my family comes to work with me. Thank you, Mr. Chairman. This bill enhances from a Class A misdemeanor to a Class D felony the penalty for the offense of child endangerment by a parent or custodian of a child 8 years of age or less if the parent or guardian knowingly exposes the child to or knowingly fails to protect the child from abuse or neglect resulting in physical injury or imminent danger to the child. It also enhances from a Class D felony to a Class B felony the penalty for a person who negligently, by act of omission, engages in conduct that places a child 8 years of age or less in imminent danger of death, bodily injury, or physical or mental impairment.
Thank you for that explanation. Members, are there any questions for the sponsor? Leader Lambert.
Move previous question.
Question's been called. Any objection? Seeing none, we're now voting to send House Bill 1817 to full criminal. Those in favor say aye. Aye. Those opposed? The ayes prevail. You move forward. Item number 2, House Bill 2163 by Representative Littleton. You're recognized.
Thank you, Mr. Chairman. This clarifies for the purpose of sexual exploitation of children offenses that the term material includes computer-generated images created, adapted, or modified by artificial intelligence, defines artificial intelligence, and generative artificial intelligence.
Thank you for that explanation. Any questions for our sponsor, Leader Lambert?
Move previous question.
Questions called. Any objection? Seeing none, we're voting to send House Bill 2163 on the full criminal. Those in favor say aye. Aye. Those opposed? The ayes prevail. You move forward. Item number 3, House Bill 2168 by Representative Littleton.
Thank you, Mr. Chairman. I would like to roll that for 1 week. We found a little something in that needs to be worked on.
Without objection, House Bill 2168 rolled 1 week.
Thank you, Mr. Chairman and committee.
And that's it. Is that all you got?
I have some more upstairs if you want me to go get them. Maybe I'll see you next week.
Maybe so. Thank you. Item number 4, House Bill 2728 by Chairman Faison.
Thank you, Mr. Chair.
You recognize there's Amendment Code 13798. Do you wish to proceed with that amendment?
Yes, sir. The amendment does make the bill.
We'll need to get the amendment in the proper posture. All right. We'll go ahead and attach the amendment. You can speak on it after that. All those in favor of attaching Amendment Code 13798 on the House Bill 2728, say aye. Those opposed? The ayes prevail. We're on 2728 as amended.
Thank you, Mr. Chair. Mr. Chair and committee, there is someone here to testify. Would y'all like to hear that first? You want me to talk about how do y'all want to go forward with that?
That's what you want to do. We'll rock and roll. We'll go out of session. Hear from Mariah Lee. You want to stand right there? It might be just as easy. He'll make sure the red light's on. You'll introduce yourself for the record. You'll have 3 minutes for your testimony. And if you run out, I may interrupt you. I don't mean to be rude, but that's just, we got 3 minutes. So
I'll
go
keep
ahead.
it quick. Hi, Chairman Dockett, members of the committee. Thank you for allowing me to be here to speak with you today. My name is Mariah Lee, and I support House Bill 2728. I'm a native Tennessean and a Justice Ambassador with Prison Fellowship, and I work and live in Madison. I am here on behalf of my brother. From my experience, I've often had to pick him up to meet with his probation officer. I've seen how stressful it is for he and my family to get where he needs to go. If he's unsure he's going to have a ride. If he doesn't find one, he runs a risk of violating his probation. In addition, he has to leave work where he is now a contributing, healthy member of society, and he puts his reliability as an employee in question when he consistently has to leave work for these meetings. By allowing virtual reporting and employer check-ins, you can help those on probation, like my brother, contribute to their workplaces and their families and faithfully meet the conditions of their supervision. Questions?
Any questions for our guest? Representative Hardaway.
Thank you, Chairman, and thank you for being here, ma'am. Can you give us real life consequences of not having, of what you're having, your brother, what he's going to have to go through now?
So just as an example, last Wednesday morning, he had a probation meeting at 9 o'clock. He is a transmission mechanic. So the work that he would have done that morning was both left for someone else to try to do, which, that's a highly specialized skill. And we had to, shuffle our schedules around as a family to try to get him to his probation officer, which we had to, because otherwise he would violate his probation. So it becomes his first priority over work, over his family and their jobs, including mine.
So the reality is it's not merely consequences for him, it's consequences for the loved ones, the support system that's helping him to transition.
Yes.
Thank you. Thank you, Mr. Chairman.
Yes, sir. Thank you. And I'm going to be out of order, but I've got 2 folks here from the district. County Executive David Morgan from Lawrence County and County Commissioner Dave Ray on the back wall back there. We can bring them up and make them give a speech if we need to. No? All right. Thank y'all for being here. All right, Representative Davis.
Thank you, Mr. Chairman. Excuse me. And I wanted to say thank you so much, because what you're doing for your brother in supporting him in that way is huge. And it helps him to build his confidence, to all of those steps that are necessary and all those hurdles that are such barriers sometimes that it doesn't go unnoticed. We see that when families, come around loved ones and try to support them in any way. And that's part of our responsibility too, is to ensure that we're providing those steps necessary for those individuals that are wanting to try to better themselves and do the right things, that we're allowing for anything that we can do to remove some of those stumbling blocks. So I just wanted to say thank you very much. And I know that it's probably been a difficult journey off and on, but we do see the efforts that families and loved ones make for so many. So thank you.
Thank you.
Chairman Halsey.
Thank you, Mr. Chairman. I don't know if you've talked to parole folks about this. Maybe this is a better question for the sponsor of the bill. Do they, or do you know if they're amenable to do this and being able to carve out the time to do it? And the employer that employs your brother, I'm assuming in that particular setting, they have the equipment or the computer process system to be able to do this as a Zoom call? Is that what you're looking at?
Yes, my brother would use his phone.
Okay,
And I will defer.
Okay. thank you.
Sure.
Any other questions for our guest while we're out of session? You got another one there? Okay. All right. Thank you for being here. We're going to go back into session.
Thank you so much.
All right, Chairman Faison, we've got, if you want to talk about your bill, then we've got some folks for questions.
Thank you, Mr. Chair. Committee, just briefly, I'll kind of give you a genesis of this. A year and a half ago, I met a man in my district who served time in prison, has a felony, got his heart right, got out of prison. I don't know if you've ever spent any time with somebody who's navigating what it takes to re-enter society. But you almost have to be a rocket scientist. All the fines, the fees, getting licensed, getting this, it is unbelievable. And I'm not saying that's all bad. You need to make sure that a person is putting their best foot forward once they've served their time in prison. This individual that I met and talked with, he was able to finally land a job, was still navigating getting his driver's license, did not have his driver's license back yet because of all the fines that had lined up for the last 10 years of his life. Once he got a job, his family, like you just heard, was taking him back and forth to work. His probation officer let him know that he needed to be there at 9 o'clock one morning that week. So he had to go to work at 7:30, work for a little bit. The probation officer where I'm from was 45 minutes away from Cocke County. He had to go to Morristown, 45 minutes away. His boss was not pleased with that and didn't appreciate it. It was tough on the family. So I came up with a notion. If the judge signs off on this defendant saying, we trust that he's a person who can, in only the occurrence that they're at work, and the work is a part of this, the work has alerted the TDOC, yes, this person is employed here, that probation officer should be able to do something. But this is the 21st century. Let's let it do a FaceTime, Zoom, Skype, something like that. That's the genesis of the bill. That's literally all the bill does. And it has to be at the behest that the judge, presiding judge, is okay with it. And that's what the bill does.
Thank you, Representative Gillespie.
Thank you, Chair and sponsor. Thank you for bringing this. I do support it. I just want to ask one question. Is there anything in here that would make it more difficult for probation officers to conduct in-home or at work visits themselves?
No.
Thank you.
Representative Hardaway.
Thank you, Chairman. And I was doing pretty good. I was following everything you said until you start using those big words. What does behest mean? Withdraw the question.
Okay.
Any other questions? I do have a question's been called. Any objections? Seeing none, we're voting to send House Bill 2728 as amended on the full criminal. Those in favor say aye. Those opposed? The ayes prevail. If you wish to be recorded as no, please see the clerk.
Thank you, committee.
Yes, sir, Representative.
I'm going to ask all those instigators out there to take note that Representative Elaine Davis and I voted together on this bill.
Duly noted. Item 5, House Bill 1949 by Representative Reagan. You recognize there's a plethora of amendments here. Is there any one or a combination thereof that you wish to proceed with?
Thank you, Mr. Chair. Yes, amendment number is 013840.
Yes, sir. Does it rewrite the bill?
Yes, it does.
All right, let's attach that amendment. All those in favor of attaching amendment code 13840 on the House Bill 1949, please say aye. Those opposed, the ayes prevail. You adopt on House Bill 1949. House Bill 1949 is amended.
Thank you, Mr. Chair. It was a good year, almost as good as the one before it. Anyway, the past few years, this bill is about an issue that has raged around locker rooms, bathroom access, and so forth for transgender individuals. The fact is that males are granted access to women's and girls' private spaces. There's been numerous reported instances as early as middle school that it at best destroys the environment of safety and comfort, and at worst ends up in life-altering rape. Regardless of the intent behind transgender bathroom access, all citizens of our state have a right to privacy. That's codified in TCA 39-13-6. So long as we allow our public institutions to adopt rules, we are failing in our duty to protect Tennessee citizens. The desire to accommodate transgender individuals cannot come at the price of our young women's safety. This bill prohibits institutions from adopting rules which force employees to violate peeping Tom laws. It effectively prohibits biological males from entering into female bathrooms and locker rooms. It also gives the victim the ability to bring civil suit against an offender. Quite frankly, this is done because our district attorneys, and I've talked to several of them about this bill, indicated that yes, they could enforce it easily right after they got through with the bank robberies, the rapes, and the murders and so forth. In short, they'll never have the staff and the time. So the civil suit piece is to allow someone to enforce this. It does include a few new exceptions that are not in the law currently. That is for first responders and good Samaritans acting in good faith. With that explanation, I stand ready to answer questions.
Thank you for the explanation. We've got a list of folks that want to ask questions, but we also have someone here to testify. So committee members, if it's all right, we'll go out of session. And we will hear from Jason Wilder. You'll have, make sure the red button is on your microphone. You'll have 3 minutes for your testimony. You introduce yourself for the record, and then you begin. Your 3 minutes will start.
Jason Wilder. I'm part of Tennessee Equality Project. Thank you, Mr. Chairman and members of the committee. My name is Jason, and I'm here as a native transgender Tennessean, also representing Tennessee Equality Project as their education manager. Tennessee Equality Project's goal is to create an equitable state for all Tennesseans, which is why we oppose HB 1949. This bill adds new language that enforces an unreasonable expectation of policing from entities. It also adds odd specifications such as the multi-person single-sex use when referring to spaces this protects, making it clear to us that this representative is abusing the section of criminal code to pass anti-transgender legislation that has wasted far too many taxpayer dollars and much of this legislator's time. First, on the reason of expectation, this language stipulates that policies must be adopted that would enforce this law without giving any clear guidance as to what entities need to be doing. This law is vague and opening up entities to lawsuits and civil action, creating an environment of fear if they do not follow accordingly. What are these entities actually supposed to be doing? What are they supposed to be adding or subtracting from their policies? It is unclear. Which leads to our second concern, target practice. Vague policies oftentimes harm the most vulnerable as companies will respond in fear rather than cooperation. False accusations are most highly done to those who are already oppressed by criminalization, such as people of color, especially Black men, according to the National Registry Exonerations, disabled folks, especially those with mental disabilities or on the blindness spectrum, according to the Prison Policy Institute, and lastly, as targeted by this language, transgender people and those who are mistaken for being trans. If a company has a policy that permits a trans person to use the restroom and it makes someone uncomfortable, this law brings action against both the trans person and the company for simply being inclusive rather than allowing for mature dialogue. The directness of designated for multi-person single-sex use, yet vagueness of the remaining language makes this clearly another bathroom bill wearing sheep's clothing. Such bills have already shown their harm today as thousands of Tennesseans, according to the last survey, are leaving because they don't feel safe here. These laws kill as well. Next Benedict, a 16-year-old, just died because they were killed for using a bathroom that they were forced to use by these laws. It is shameful and furthers the point that we do not need more laws like this. We as a state need to do better. We can start by not criminalizing both Tennesseans and companies for inclusivity. This state is our state too. Please represent us and vote no on this legislation. Thank you for your time today.
Thank you. Representative Johnson.
Thank you, Mr. Chairman. You spoke about the student, I believe was 16-year-old in Oklahoma who was just killed by violence in the bathroom. Can you speak a little more to the violence that typically happens or to the things that typically happen in a bathroom? And who actually are the ones more at risk, the people at risk? But if you could just tell us a little bit more about that.
Yes, Representative. So, as I mentioned, Next Benedict was a 16-year-old non-binary identified student who was recently killed in a female bathroom because that's what the state of Oklahoma forced them to use. And this is not an uncommon occurrence, unfortunately. I myself have worked in many different industries, gyms, places like that, in which violence has been opposed onto many transgender people. I myself have been attacked in a bathroom before because of the fact that I am a transgender male. And it's because of these laws that I am forced to use restrooms that make other people uncomfortable. It's a lose-lose situation. And these kinds of laws affect transgender people majorly. But as I said before as well, they also affect our disabled and our people of color in the state as well, because of the fact that the language is so loose that it can end up being used to target basically anyone.
Thank you. I appreciate that.
Any other questions or comments for our guest, Representative Hardaway?
Thank you, Chairman, and thank you for being here. Is there a way to fix this bill?
In my belief, Representative, I think that this bill is not fixable because of the fact that it is targeted, and the representative has very clearly made that true, that if this bill was to protect, then it would simply amend some of the language that currently exists to maybe more specify what businesses should do in their policies, or maybe more specify what companies can do to protect themselves in civil action suits or for individuals as well. But instead, what it does is, like he said, target and make fear in businesses instead.
Have you put together language, not you necessarily individual, but has there been an amendment that has language that could fix the current law, not his bill, but the current law? Where it would make his bill unnecessary?
No, Representative, mainly out of the fact that, again, this bill is targeted and the current language is already pretty well set in the fact that it gives room for companies and businesses to already make policies in either direction that they believe is responsible. And I think that that is their right as private entities as well. And that if we want to actually help trans people and help all people in these situations, we should leave it up to businesses.
All right, thank you. Looking forward to working with you, perhaps next year, on responding legislatively should this bill pass. Thank you.
Thank you.
Anyone else have questions for our guest? See, now we're going to go back into session. All right, Representative Russell, you're recognized.
Thank you, Mr. Chairman. One of my constituents emailed me this morning and wanted to know how this would affect small children that climbed up under a stall in the bathroom. Would it cause any kind of legal action taken against the child or the parent?
Obviously not. Minors in that particular case are exempt under current law. This does not change that.
Thank you.
Representative Fritz.
Thank you, Mr. Chairman. Thank you, sir, for the bill. Is there an intent in this bill to protect minor children from adults of the other biological gender in them being intimidated or frightened or perhaps harmed?
Straightforwardly, the answer is yes, but it's not limited to that. Ladies and gentlemen of the committee, I had not planned on presenting this, but let me do this in light of these comments that were made. Loudoun County, Virginia, May 2021. Male student 15 identifying as female raped a female student 14 in the girls' bathroom. Instead of prosecuting the transgender student, he was transferred to another school. On October 2021, he assaulted another female student in a classroom. The grand jury report reveals that the school district attempted a cover-up, knowingly sought to minimize the sexual assault. Ask Academy, New Mexico, October 2021. Male student identifying as a female sexually assaulted a female student 12 in a girls' bathroom. Following this allegation, other students stepped forward and alleged sexual assault was frequent, but students feared being labeled a bigot for coming forward. Edmond Memorial High School, Oklahoma, October 2022. Male student identifying as female approached 3 girls in a girls' school bathroom. The victims told the transgender student they wanted to be left alone. The transgender student proceeded to physically assault the girls, resulting in injuries, including concussions. That's a sampling of just the last 3 years. Despite, excuse me. I think that is sufficient to establish the point, but I will say, this bill was brought to me by constituents from my district. And then, in fact, a company bought out another company in my district and changed the policies that were working fine to create the problem. This bill is intended to keep the situation from being worse.
Representative Fritz, you have follow-up?
Yes, sir. Thank you, Mr. Chairman. Again, I appreciate you carrying the bill. And I do think we have a responsibility to protect not just our youth, but all from being intimidated and coerced into things that have become recently or new cultural norms. So thank you.
Representative Johnson.
One thing I wanted to bring up, do you feel like this bill is anti-business? Because I've heard from some businesses that they feel that it's telling them what they need to do.
The answer to your question is no. The legislature tells businesses what they have to do all the time. Everything from reporting profit, losses, paying taxes, setting standards for public access. This bill is no different than any other.
So you don't feel it's anti-business?
No,
at
ma'am,
all?
I do not.
Okay. I haven't had time. You just gave us those incidences. I'm curious, just on a quick Google search, the one in Virginia, what I saw, it was a male who was wearing a skirt. I'm out and about a lot in my life, and I know that there's guys wear skirts sometimes that have nothing to do with being transgender. And so you can go to a concert, if it's a goth concert or something like that, you'll often see guys wearing skirts, and it has absolutely, they are heterosexual males, they just wear skirts. So I don't think you're equating the same things here.
Your characterization of the incident in Loudon is incorrect. The male student identifying as a female raped a female student, whether they're wearing a skirt or not. They were identifying as female using a female facility, a designated one for females. The fact that this individual was wearing a skirt was irrelevant to the fact that that took place in a female restroom, which was being used by this individual because he claimed to be transgender.
As I told you, that was a quick Google. I haven't read the full article because I don't have time, but it did not say he identified as a female. It said he wore a skirt. And that's two different things. I will
read the
read
entire
further.
article, trust me, I told you the truth.
I'll
All right.
read it for myself. I appreciate you telling me your side. I will read it for myself. And until I'm convinced, I will be voting no on this bill because it's doing nothing to protect the kids like the 16-year-old who just this past week died in a bathroom because of who they were.
Leader Lambert.
Move previous question.
Question's been called. Any objection? There's objection. We're voting on previous question. Those in favor of previous question, say aye.
Aye.
Those opposed? No. Ayes prevail. We're now voting on sending House Bill 1949 as amended to full criminal. All those in favor say aye. Aye. Those opposed?
No.
The ayes prevail. If you wish to be recorded as a no, please see the clerk. Item number 6, House Bill 2348 by Representative Reagan. You're recognized.
Thank you, Mr. Chairman. House Bill 2348 is relative to the support of terrorist organizations. In the 21st century, terrorist organizations are enabled by technology to spread their message even to our own communities. After the October 7th attacks, Hamas supporters in our own country called for violence and genocide and solicited material support. Taxpayer-funded universities became hotbeds for anti-Israel, anti-America rallies and publications. It is an insult to our taxpayers that we allow their tax dollars to support those who hate them. This bill prohibits the use of taxpayer-funded entities from furnishing meeting spaces or electronic or print platforms for designated terrorist entities. To clarify, this does not violate the First Amendment because it does not apply to citizens expressing opinions, but to terrorist groups planning violence. We have a responsibility to ensure that the money this state takes from taxpayers is not used to harm innocents. If anyone has questions, I have a list of the terrorist-sponsored organizations from the State Department and would be glad to share that.
Leader Lamberth.
Thank you, Mr. Chairman. And Chairman, well, so do I, Representative Hardaway, if I may. Yes, sir. Thank you. So, Chairman, on this bill, I know on another bill that you had, and I think just the previous one, you and I had a conversation before about criminalizing an entity versus an individual. And I was looking at the language of this, and it seemed like this had that same language in it. And again, entities can, have criminal penalties attached to them, administrative, civil penalties, but an actual criminal penalty ordinarily that involves jail time is aimed specifically at an individual. So in the language of this bill, does this criminalize an entity or an individual?
This creates a Class C fine-only felony. It's a $3,000 fine to the organization or entity that allows its meeting spaces or its print media or its electronic media to be used for the purposes specified in this bill.
So, and that's how you deal with that question in this bill then, is that you make it a fine-only felony?
That's correct.
Okay, I can follow up with other questions later. Thank you, Chairman.
Representative Johnson.
Thank you, Mr. Chairman. Does this bill include neo-Nazis and white supremacist groups as well? Because I know due to First Amendment, certain state entities have allowed these folks to organize. They are also terrorist organizations. So are they included in this as well?
The terrorist organizations are listed on the State Department's website. I have 5 pages of them if you wish to hear them, but they are not included in this list.
Then I can't support this bill because we need to include the true terrorists that just showed up this past weekend in Nashville.
If the good representative could get the State Department to put them on the list, they would be included.
I'll work on that.
Leader Lamberth.
Thank you. And I concur for my colleague from Knox County. I mean, if a group of Nazis is not on a list somewhere or another of an absolute terrorist group, there's 6 million Jewish families that would certainly agree that they should be. And so I stated this weekend online, and I'll say it again publicly, Nazis of any kind are not welcome in this state. And so I want this bill to definitely address some of that. I also have some additional questions, just how we structure this. But I mean, Israel is in a fight for its literal life right now. And the Israeli people obviously have our support, and the Jewish people have our support. I think virtually everybody on this committee has said that publicly. I for one, think there could be some improvements in this bill. I like where you're headed with this, but I do have some questions just about the e-felony and how that works. That may work fine. But again, I agree with my colleague from Knox County, and I'm glad that was said, that there are definitely some other groups that, if possible, I think it would be good to have included in this bill.
If I could clarify, under Section 1, subparagraph 2, it's an offense for an entity that's supported in whole or in part by public funds to knowingly provide meeting spaces or other forms, including but not limited to electronic or print platforms, to a designated entity by which the designated entity may solicit material support, recruit members, encourage violent action, or advocate divisive concepts as defined in 49(7-1902). The point is, unless you designate these people officially, anyone can stand up and say that's a terrorist organization. And at that point, we have no way of being correct in saying yes or no. By saying designated entity and pointing to a source where these are designated, it clarifies the problem you're talking about.
Representative Hardaway.
Thank you, Chairman. And my concerns, Chairman, are along the same lines. I understand that it's more convenient and probably a cleaner bill by being able to point to the what in essence would be international terrorists and what's already defined as domestic terrorists. However, I agree with my colleagues that this needs to include any and all organizations which are about terrorism, whether it's about religion or race or gender or it doesn't matter what it is. If it's about terrorism, then we should oppose it in any way, shape, or form. I'm with you with your intent, but I'm not sure if the bill is ready for prime time. And I don't know if you're willing to roll and give us a chance to give you input, but I would ask you to consider that. So I would be in a position to vote yes.
Thank you, Mr. Chair. And again, section 2, it says advocate divisive concepts as defined in 497-1902. Among those are included promotes division between or resentment of a race, sex, religion, creed, nonviolent political affiliation, social class, or class of people. That encompasses what you're talking about, sir. It's already in law, and this references that.
And at some point, I'll ask, I thank you for that. At some point, I'll ask that we either go out of session to consult with our legal counsel or stay in session and consult with Leader Lambert.
At some point, you're going to ask that. Is that point now or is that later?
Thank you, Chairman. We're at that point. I'd like to start with Leader Lambert.
Okay, Leader Lambert.
Well, my name was called. Chairman, it sounds like several folks here think you have a good concept. It just may need a little more work. Would you be opposed to rolling in about 2 weeks and just keep the conversation going? I mean, because it sounds like all of us are saying, look, there are certain racist, terrorist, horrible groups that just shouldn't be on a public college campus. And look, that's an open forum. It's First Amendment. Anybody can think and say whatever they want to. But when you start advocating for the death of entire ethnicities, then there's no room on our college campuses for that, in my opinion. And I think that's why you brought the bill. So it sounds like it's a good concept, but it needs a little bit more time. But what are your thoughts, Chairman?
I'm at the will of the committee, obviously. I will point out, though, that the reference that I just made contains items A through P of divisive concepts, which includes a lot of the questions that have been asked about, as was referenced in the bill. But I could take the time to read these to you in entirety, but I think that would be wasting your time when you can read them yourself. I did mention one specifically, item J, which I quoted, which covers specifically the groups that we're talking about as not being allowed in this situation. So I would encourage the committee, if the committee so directs, I will roll for further discussion. However, that follows that is that by specifying, like I said, these 14 plus categories that are already in our code and saying that those are defining of what we're talking about in the bill itself, the paragraph that I read you to, subparagraph 2 there, I think we've covered all the bases without specifically going over them again.
All right, that time is here, Representative Hardaway. We're going to go out to legal services. We're out of session.
Michelle Fogarty, Legal Services. The bill as drafted applies to a designated entity. A designated entity, that term is defined as used in this chapter to mean an entity designated by the U.S. Department of State as a foreign terrorist organization in accordance with 219 of the Immigration and Nationality Act, or by the United States Department of the Treasury as a specially designated national in accordance with 31 CFR Part 500. So the bill would only apply to a designated entity as that term is defined as used in the chapter. It's a defined term in the chapter.
Mr. Chair,
Yes, sir.
could I ask the legal counsel to opine on the last portion of subparagraph 2 there? Or advocate divisive concepts as defined in 49-7-1902?
That would only apply to a designated entity that is attempting to advocate for divisive concepts. If they're not a designated entity as that term is defined in this chapter, then this does not apply to them. Because a designated entity is a term that's defined as it's used throughout the
Mr.
chapter.
Chair, I will ask to roll this bill to add words to clarify that, in fact, it applies to anybody who's violating that 49 code that I cited there, 7-1902.
All right, we'll just hold tight a second. We'll go back into session. Representative Towns? We'll go back out of session. Representative Towns has a question.
Mr. Chairman, I
for legal
really
services.
appreciate it. Tell me this, I didn't hear domestic. I heard foreign, but I didn't hear domestic.
Michelle Fogarty, Legal Services. A designated entity is defined as used in this chapter as an entity designated by the U.S. Department of State as a foreign terrorist organization.
That's more of a reason for us to roll this bill to get it right, okay? Because our troubles are going to be domestic for the most part, not underestimating foreign intent, but we need to make sure that we're protecting the shores from our own domestic terrorist action or whatever, bad actors. So, Mr. Chairman, Mr. Leader, thank you for your suggestion too. Mr. Chairman, thank you for that inquiry.
Yes, sir. Thank you. We're going back into session. Sponsor, you want to roll it for 2 weeks?
Thank you, Mr. Chair. That is my desire to add some words that will clarify the issue.
All right. That objection, we'll roll House Bill 2348, 2 weeks.
Thank you in committee, Mr. Chair.
Item number 7, House Bill 2126, roll 10 spaces. Item number 8, House Bill 2031 by Representative Barrett. You are recognized.
Thank you, Mr. Chairman, members of the committee. House Bill 2031 seeks to address a situation in the law regarding disorderly conduct as it relates to intentionally blocking roadways, streets, and conveyances. Currently, under the law, it is only a Class A misdemeanor. This will increase that to a Class D felony and also adds a civil right of action for anyone that is damaged by that intentional act.
Thank you for the explanation. Any questions for the sponsor? Representative Hardaway.
Thank you, Chairman. Is this aimed at protesters or just anybody?
Thank you, Mr. Chairman. Representative Hardaway, no, sir. This actually addresses a multitude of issues that we've seen across the state. Not only situations like we saw recently in Memphis with protesters that blocked the bridge, but also we have hot rodders and motorcycle people. We have YouTubers that are blocking interstates so that they can show out and post these videos on the internet. So this is going to address all of those situations.
Well, now, if you had said that second half first and left the first half off of it, then I might consider the bill. But if any part of this is aimed at protesters, those who are exercising their constitutional rights to express their displeasure with government, then I've got a problem with it. And if there's, it seems to me a misdemeanor, which I believe is the current penalties are sufficient. It's just difficult for me to get to the point to where we keep trying to execute legislation that puts a chill on constitutional rights to protest. I've got a problem with that. So I can't support your bill as written, and I'm not sure what you could do to write it so I could. If you have a way, I'd be interested in hearing it. 'Cause it sounds like on this, I could walk the streets and go across a crosswalk, walk too slow, look at somebody who blows their horn at me, and subsequently, they could have me charged with a felony.
So Representative, I think we're conflating a couple of issues. Constitutionally, the right to protest is protected under the First Amendment. You have the right to protest, but parades and protests that go out into public ways, those are all done through permitted processes. And so when you have a situation where one of these permitted protests walks up a ramp of an interstate and blocks a bridge and isolates an entire city from being able to get into or out of the city, tying 5,000 people up into a traffic jam, not only are you putting everybody in that traffic jam at danger, you're putting everybody that needs to be able to get from Arkansas into Memphis to get to a hospital in danger. You're putting everybody in that protest in danger. So when the leader of that protest has 500 people walking behind them and they follow this person into harm's way and they get hurt, that person needs to be responsible for that. And that's what this bill is seeking to do. We are trying to chill the rampant violation of the law by going outside of what is permitted in the areas that you're not supposed to be doing these protests. So that is part of it. Yes, sir.
All right, and you just confirmed what I still wasn't sure about, but you led off with Memphis this time. So
This time,
I'm
yes,
sure
sir.
this bill is aimed at Memphis again. But I would ask you whether you could address the question that I posed about me walking the crosswalk. Somebody blows their horn because I'm walking too slow. And then I turn and say something not ugly to them,
You would never
but
do
how
that,
much
sir.
I love them. And they take that the wrong way and charge me with obstructing their progress because the light changes because I talk slow.
So in order for there to be a violation of this particular statute, Representative, it would have to rise to the level of disorderly conduct anyway. So an individual example that you're talking about would not apply to this statute.
All right, that's comforting in that sense, but I'm still having problems with your bill. I believe that it should be constitutionally suspect if it's not. And I would ask you to reconsider raising the right for a citizen to protest their government. And that's what it was in Memphis now. It was about whether the folks who live in Palestine are all terrorists or whether those little children deserve the right to live. That's what that protest was about, okay? And for all those folks to be labeled felons and to be subject to civil penalties, that's what I believe would be un-American. So I won't be able to support your bill, but I appreciate you engaging. Thank you, sir.
I would simply respond, Representative, that the First Amendment already has limitations. There are certain things that you can and can't say in certain places that you can and can't say them. And this is just one of those situations. So again, no matter what the issue is that's being protested, I had someone ask me, well, what about the truck drivers that are doing the convoys and blocking the interstate? That's on the opposite end of the spectrum. It's the same thing. If they're intentionally blocking the highway and putting people at risk, then they're going to be subject to penalty as well. This is not isolating Memphis or Knoxville or any other urban area. It's not isolating any particular viewpoint. This is saying that it is a dangerous situation when you put everybody on a public street or interstate at risk by doing something that you're not permitted to do.
And I would agree that that's the nature of protests, to disrupt. What we disagree on is trying to put a chill on the individuals who want to have redress to their government and tell them if you do so, you're going to have a felony and you're going to put all of your assets at risk. That's the part where you and I disagree. So unfortunately, well, fortunately, I won't support your bill. Thank you for the discussion, sir.
All right, just about everybody on the committee has got their name on the list to speak, so we'll go alphabetical order. No, I'm just kidding. Representative Fritz, you're next.
Hey, thank you, Mr. Chairman, and Representative, thank you for bringing the bill. Excuse me. I think we're missing a couple things here. We do have a right to peaceably assemble. And when we start to do things that disrupt other people's right to get to a hospital, we should question that. And I think we use specific examples here in some of the questions, and I love and respect my colleagues for those. But our Constitution doesn't say things about being disruptive. It says peaceably assemble. So I appreciate you bringing the bill. I think most of us should expect our government to stand for the unrestricted flow of commerce and trade, and yet allow those protests against the government to occur around our buildings and around government here in these facilities. But shutting down highways or setting up drag racing events is something we should stand against. So I support your bill. Thank you for carrying.
Thank you.
Representative Davis.
I thought I was going to be lower on that list, but anyway. But no, I appreciate it, sponsor. One of the things that I wanted to touch base on when just kind of in researching this bill was with regard to conveyances and railroads. Apparently, from what I understand from some of those individuals that are in that industry, they're having gangs that are blocking the railroads from moving back and forth so they can then steal items from those trains. And so this is important in order for commerce to continue. And so I wanted to say, excuse me, thank you for that. The other thing is, I do remember in Knoxville, we had a situation where some of our roadways were blocked. And there was a doctor that was supposed to go to the emergency room at UT Hospital, and he was not able to go through. And there was an article about it, about I don't know what happened to the family that he was supposed to operate on and the results of that, but he was highly upset, and for good reason. He has a responsibility and a duty to try to save someone's life, and he's being blocked. And if I had been part of that family, I would have appreciated something like this if my loved one had died. Thank you.
Representative Gillespie.
Thank you, Mr. Chair and sponsor. Thank you so much. I completely support this legislation for a multitude of reasons. You touched on one earlier, and as the members of this committee know, and probably some of the audience, people listening, I have tried very, very hard with some success to make our roads safer with reckless driving and drag racing. And there was an incident, anyone watching this can go look on YouTube, where there was a individual that did donuts. It was not classified as drag racing or even reckless driving somehow, that was blocking Interstate I-240 near the Walnut Grove intersection near Baptist East. And there was an ambulance there that was stuck in that. So I just want to put everyone listening, imagine if your child was in that ambulance, and the reason it was being blocked from saving that child's life is because someone wanted to do donuts in the street. Those people should be penalized. They should be punished. They're not right now for a variety of reasons. This gives law enforcement and prosecutors more tools to be able to go after those people. I also want to say, in the protests that we just had in Memphis, there was an incident in Arkansas where there was a pediatric patient that was actually had to be taken out of his car by the Arkansas State Police. They saved that child's life. The reason they had to do that is because the bridge was blocked. The other bridge was closed that weekend due to construction. So there was literally no other place to take that pediatric patient other than Le Bonheur. Those people were stopped. They could have died. Thank God they did not. So for those reasons, I fully support this. Thank you so much.
Representative Johnson.
Thank you, Mr. Chairman. Would your bill have prevented John Lewis and those folks from walking across the Edmund Pettus Bridge?
Thank you, Mr. Chairman. I didn't know if we were allowed to have a back and forth or not.
I'll allow you to do that, yes, sir.
Thank you, Mr. Chairman. Representative, look, I don't know the answer to that question because I don't know the exact details and what the intent was of the individuals at that time. But again, this is a public safety bill. And what this bill is trying to do is protect people that are bystanders, that aren't there for protests, that aren't there for drag racing or whatever the issue is, but they get caught up in this, and it causes ripple effects that we're trying to eliminate, the ripple effects. So that's the answer that I would give you.
Okay, I'll stop there on that one. But rampant, I think that rampant might be a little extreme. I can think of a handful of times that I've seen the traffic stopped. I know in some instances it has actually been approved by the officers involved. And that's, I think, I appreciate you coming to me before you brought these bills, because I had a little bit of a chance to tell you, we had a march in Knoxville, and it ended up going across Gay Street, and they stopped for 7 minutes. I didn't know it had been approved. And so a lot of times there's a misunderstanding between, somebody thinks it's been approved that we're blocking this road, but because that's the way we've done it in the past, and people get caught up in this not knowing, what the rules are and what's been approved. But I think even in Memphis, at least one of those, blocking the bridge or the interstate or something, was approved with the police. And so I think it just creates a problem of folks not knowing, and that we can do better here, especially talking about doing donuts and traffic violations is different from people in the road, and we can write legislation that addresses the traffic problems. But I'm not convinced that we need to make this a felony for folks who are exercising their First Amendment right and may be under the impression that they have the right of way at that time to do that. So I can't support this bill because I think it leaves too many of those unintentional consequences for folks.
Representative, if I may, the discussion that we had, the key part of this is the intentional element. So there has to be an intent that is proven in order for there to be penalty. And so in a situation like you're discussing where police officers allow it, or there's a permit to be there, or there's been some authorization in order to be in the street, that's different. So for instance, I know that there was some mention about the protest this weekend, or whatever demonstration that was this weekend. They were on the sidewalks. If they were in the streets and intentionally blocking streets and holding up traffic, then this would apply, and those people should absolutely be taken to justice for that.
But what if the group was so large that it took a while to cross the street, and it did prevent some people from pulling out for a while? That happens just on a crosswalk. The example that my colleague gave, it didn't count in that example, it was just him. But what if it was a group that was just crossing the street, but it took a long time to cross the street? I just see where this leaves too much open to interpretation, and that we are going to be giving felonies to people who maybe thought they were doing the right thing. And it's hard to prove you didn't know there was no exception for blocking the roads in this particular protest. It's just, with a lot of people, there's just too much. And I think a felony for and proving intent is near impossible here.
Well, again, Representative, I would go back to the intentional part of that, the intentional obstruction, those two things together. And what you're talking about, if a group is so large that it takes them a little bit while longer to get through a crosswalk or something along those lines, there's no intentional element of that. Just like somebody in a wheelchair that takes a little bit longer to get through a crosswalk, and somebody may have to hold up for the light to change, that's not an intentional obstruction of a roadway. So it's two different things.
Yeah, it's always in the eye of the beholder, though.
All right, we've got a lot on our list, so we're going to keep rolling here. Representative Howe.
Thank you, Mr. Chairman, and thank you for the bill. And listening to the discussion, of course, I serve in transportation, so somewhat familiar with federal law. I'm confident that if a federal prosecutor had chosen to do so, they could have brought charges against those protesters who chose to block the DeSoto Bridge for 5 hours and hold about 15,000 people hostage, is what I heard. Primarily based on the Interstate Commerce Clause, which has been around a long, long time, which prohibits the willful disruption of commerce. The DeSoto Bridge, Highway 40, is the primary east-west freight corridor coming from west of the Mississippi into Tennessee, into Georgia, Kentucky, North, South Carolina, all the way to Florida. I strongly believe in the ability to protest. There have been a few times that I felt like doing it myself, but the Supreme Court has opined that right. This country was built on protest, but the Supreme Court has also opined that there are limitations. You can't scream fire in a crowded theater when there's no fire. People get trampled to death trying to get out. So there are limitations to the protests. I support the protests, but I don't believe they have the right to put other people's lives in danger while they're doing it. Thank you.
Thank you. Representative Towns.
Chairman, thank you as well. And thank you for bringing the bill to allow us to discuss the bill. We've chatted about this. I want you to think about, and all of us to think about, being 19 years old, being 18 years old. Now, for some of us, that may have been a very long time, but but try to go rewind in your mind just how impulsive we were, how we thought we knew everything, how we thought the old folk were all old-fashioned and washed up and didn't have any sense, and they were behind the times. Just think about how your actions are in a particular situation that you may, as old folk would say, probably back then, make a mountain out of a molehill, but you reacted to it. A lot of our protests across the country and across countries around the world, you're going to have young people that are trying to find their way and develop themselves, and they're not going to always be right, and they're going to make mistakes. And to designate them with the felonious letter by their name at 18 years old, 20 years old, just about wrecks their lives. Now, when you're 25 years old or 30 years old, your mind begins to change. Some things you just won't do that you did when you were 19 years old. You won't do it because of your growth and your wisdom. So there has to be some redemption quality in our legislating, our mandating laws for us to live under, so that we don't prevent a second chance for young people. You're not gonna find a bunch of old guys and ladies out there on the bridge. It just won't be. They're not gonna be there. Knees can't take it. If it's necessary to run, you just can't do it. And their mind changes. Protest a little differently. They may write or call. So I want you to look at how can we and what should we do in the event that that is a protest somewhere in the state to help not write our young people off with a felony. What do you think we should do?
Well, Mr. Towns, we have all sorts of elements in the code, criminal code in particular, regarding minors and criminal violations. The question that I have, as much as I sympathize with that 19-year-old, having been one, as you said, a long, long time ago, actions have consequences. And when you are so selfish as to put everybody else around you at risk of injury, both pecuniary injury and physical injury, then there has to be consequences for that. And you have to be dealt with. As much as we would all love to deal with a lighter touch in some situations. I don't feel like this is one of those. I feel like this is an important enough issue with as wide-reaching an impact, possible negative impact on people, that we really have to step up and do something extra to try to get the attention of these young people.
Mr. Chairman, thank you. And I comprehend, and I could in some areas agreed. I'm going to pose this to you again, or to the body again. There was a time in this country that we had a wild, uncontrolled, out of order pandemic as it relates to drunk driving. It was all over the country. People dying like 40 going north, kids. We dealt with it in a way, and sometimes people have to be prosecuted, no question about it, but we dealt with it in a different way. And this is deadly stuff, really deadly stuff that we forgot because we quelled the problem to a large degree. It's nowhere close to what it used to be. But we dealt with it in a way where we were able to do some other things, PSA announcement, getting involved in the schools, Mothers Against Drunk Driving, and other things that allowed us to stop the surge while simultaneously trying to protect our young people in the future and allow them to mature out of it. Now you have Uber, and back then you had somebody else, friends don't let friends drive drunk, and all these kind of, it worked. And that's serious stuff, because you could leave home and not come back home because some young kid celebrating a birthday drank too much or stole the mom and dad's liquor, got into the stash, and they steal the car. All that stuff happens. 16, 17, 18 years old. But the adults, and don't misunderstand me, because there's some extreme behavior, really extreme behavior that some of our young people are doing, you know, across the country with guns and other things. It's not necessarily the gun, it's how we're not raising our people, our children, like we once raised them. The love and the understanding, the reproof, it's not the same. But we were able to conquer that problem, thank God. And I'll leave you with this, members, that the old folk had another great saying. They would always say, look, there's always more than one way to skin a cat. And so there's always more than one way to accomplish the same thing. And question is that, and we need to address it, but do we need to accomplish it this way? It needs to be addressed. It needs to be addressed, because if I'm a doctor or my person's in the hospital or needing in an ambulance and they bleed out, oh man, I'm upset. I'm mad, and I want some hind part. Okay, I mean, I'm going to be upset because that's my family member or my friend. You know, so we have to address it. But how do we best approach it is what I'm asking us to, as a body, to figure out how to deal with it. You know, Mr. Chairman, thank you, sir.
Yes, sir. Thank you. Last one I've got on my list. He's a repeat. Representative Hardaway. You can.
Mr. Chairman, and I want to be collegial, so I'm going to ask my colleagues if I can forego, and they won't call the question in full committee.
All right. Any other questions for the sponsor? Seeing none, we're voting to send House Bill 2031 on the full criminal. All those in favor say aye. Aye. Those opposed?
No.
The ayes prevail. If you wish to be recorded as a no, please see the clerk. You move forward. Item number 9, House Bill 2159. Representative Barrett, you are recognized.
Thank you, Mr. Chairman. House Bill 2159 seeks to add a paragraph to TCA 3917-902, which is the criminal statute regarding obscenity, to create a civil right of action for violations of that statute. The purpose of the bill is to provide another tool in the toolbox to discourage the production of child pornography and obscenity in Tennessee. Obscenity is already illegal under federal law and Tennessee law as well. Obscenity is not regular pornography, what the courts call indecent pornography. Obscenity is basically child pornography and other really horrible things. It is the worst of the worst, and it has no constitutional protection. It is basically stuff that you can't imagine and don't want to imagine. My bill allows parents and any individual to sue someone who publishes this material on a website to make them remove it. Most of it is already illegal, but prosecutors can't go after every offender. This is a tool we are going to use to help our law enforcement and parents get this material removed from the internet. And with that, Mr. Chairman, I renew my motion.
Thank you for that explanation. Any questions for the sponsor? Seeing none, we're voting, in the nick of time. Representative Hardaway.
Thank you, Chairman. Is there a definition in your bill, or does the definition for obscene come from current statute?
It is already referenced in statute, Representative. It does not change any definition.
All right. Thank you, sir.
Thank you. Any other questions? Seeing none, we're voting to send House Bill 2159 on the full criminal. Those in favor say aye. Those opposed? The ayes prevail. You move forward.
Thank you, Chairman and committee.
Members, a moment ago, or several moments ago, we moved House Bill 2126 by Representative Grills down a few spots. That's item number 7. We're going to pull that one back up. So we're on item number 7, House Bill 2126 by Representative Grills. You are recognized.
Thank you, Mr. Chairman. Before I get started, I want to say that last week my assistant was out Thursday afternoon and Friday, and I had some things I needed to get done. And your assistant was graceful enough to help me, and she went the extra mile, not just help me, but help me over and above what I asked. So thank you, Emily, and congratulations, Chairman.
Yes. That's right.
This legislation would allow the juvenile court judge the option of moving any juvenile 15 years and older and up to be transferred to adult court for the crimes of organized retail theft or theft of a firearm and attempting to commit these crimes. I ran this bill back in the special session. This is something that has happened in my district from time to time, and I'm just wanting to give our DAs and our juvenile judges another tool in our toolbox to help combat these types of crimes.
Thank you for that explanation. Members, are there any questions? Representative Towns.
Mr. Chairman, thank you. Thank you for the bill. Is this on the first offense, second offense, third offense? Any offense? First offense. Okay. Thank you, Mr. Chairman.
Representative Hardaway.
Thank you, Chairman. I think I'm good with this in concept. But I just have to ask myself, what am I missing here? Does the judge, juvenile court judge, maintain judicial discretion?
Yes, sir. That's the intention. The DA will petition the court to move this individual to adult court. They will petition that juvenile court, and that judge will then make a ruling, and they will either send that individual to adult court or keep them in the juvenile court system.
All right. And how will that differ from the discretion that the DA has now and that juvenile court has now?
This is not a transferable crime currently. It's a delinquent act, so therefore it can't be transferred to adult court.
All right. So are you, in the description, are you intending to encompass any shoplifting, stick of gum, or are you after those who are doing these mass runs on stores and putting everybody at risk, running around with mallets and things?
Chairman Doggett, if Representative Hardaway would like to hear from legal, 3914-113 gives a description of what the organized retail crime is referencing. Would that be appropriate?
I'll make that request, Mr. Chairman.
All right. That objection will go out of session to hear from legal services.
Michelle Fogarty, Office of Legal Services. The bill as drafted only applies to organized retail crime and theft of a firearm. Organized retail crime encompasses receiving, possessing, selling, or purchasing any merchandise or store value card obtained from a fraudulent return, acts in concert with one or more individuals to commit theft of any merchandise with a value greater than $1,000 in the aggregate over a 90-day period with the intent to sell, barter, or trade the merchandise for monetary or other gain, or to fraudulently return the merchandise to a retail merchant. It does not encompass just simple theft.
Yes, sir, Representative.
Thank you, to legal. Would you, with this, in your opinion, would this apply to an individual who did a stick of gum? Or is there an amount attached to this?
It applies to a person who acts in concert with one or more individuals to commit theft of any merchandise with a value of greater than $1,000 aggregated over a 90-day period, with the intent to sell, barter, or trade the merchandise for monetary or other gain, or to fraudulently return the merchandise to a retail merchant.
So this would not apply the first time if the theft was under $1,000.
It has to be a person acting in concert with at least one other person, an aggregate value of over $1,000, and they have to have the intent to sell, barter, or trade the merchandise for monetary or other gain, or to fraudulently return the merchandise to the retail merchant.
Right? Could we speculate, or could you opine on whether this would, the $1,000, is that the aggregate of all of the individuals involved at different times? Or will this have to be the aggregate for the individuals involved in the one incident?
The value applies to the aggregate of the merchandise over a 90-day period. For example, if this was done 2 or 3 times within a 90-day period and the aggregate value was $1,000.
So it could be 1,000 people and they do $1 piece of gum each, then it would apply to them. And of course, I'm being facetious in that stick of gum.
If they do that with the intent to sell, barter, or trade the merchandise for monetary or other gain, or they attempt to fraudulently return it to the retail merchant.
Okay. Thank you, ma'am. Thank you, Chairman.
Yes, sir, Representative Towns.
Thank you again. Legal, would this also apply to someone that purchased the merchandise? If, in other words, a group of guys, girls go out and steal the merchandise, and then I'm unsuspectingly, they sell it to me. I'm thinking it's theirs, and I buy it. Would it apply to me as well? I think I heard buy as well.
Michelle Fogarty, Legal Services. In regards to a merchandise or store value card, it's receives, possesses, sells, or purchases any merchandise or a stored value card obtained from a fraudulent return with the knowledge that the property was obtained in violation of law. So you would have to have knowledge that it was unlawfully obtained.
Okay, because people get stuff maybe hot and they take it to the street or take it to their friends and they sell it, and they may not I think it's my stuff. They think it's my stuff, but I actually stole it and I sell it to them, and I would have to have knowledge of it being stolen or obtained fraudulently for it to apply. But it would apply, what I'm hearing you say, it would apply to the buyer of the merchandise as well.
If they had knowledge that it was obtained in violation of the law, yes.
Right. Okay, thank you.
You're welcome.
Any other questions for legal services? You almost raised your hand. All right, we're going to go back into session. Representative Johnson.
Thank you, Mr. Chair. I guess what really concerns me, we talk about 15 years old, 16 years old. It sounds like this could be two high school kids, one chatting up whoever the the person working in the store is and the other one takes some things, not necessarily a ton of folks running through and grabbing a lot of stuff. Certainly it is a crime. It needs to be dealt with. But this is the age where we can change the trajectory of these young people. And if we turn them over to adult court, and they aren't insured any kind of ability to rehabilitate and some of the services that are so needed, I really just feel that our juvenile court is the best place. They handle this stuff every single day. We have such good judges in our juvenile courts in Knoxville. I wouldn't want anyone else to handle a 15 or 16-year-old in this instance. So I just think it's critical that we focus on rehabilitation. So when those kids turn 18 and get out into society, they have learned from their mistakes and continue on in the right path instead of potentially being with folks that are just going to push them more in the direction of crime.
Thank you, Mr. Chairman. And to that question or that statement, those good judges you were referring to, they will have the discretion to make the decision whether to send that individual to adult court or to keep them in the juvenile court system. This is not pushing them. This is giving the DAs and the judges the opportunity to, if they feel like this crime needs to be charged as an adult, they will be able to do that.
I just think that they should stay in the juvenile courts.
And that judge has the ability to keep them there.
Because not all judges are the same. We have good ones in Knox County. I don't know the rest of the counties. I know they have good ones, but we need to put the young people, make sure that we put them on the right path.
I agree.
Representative Davis.
Thank you, Mr. Chairman. And essentially, sponsor, that's exactly what I was going to ask you, was the judges, according to your bill, they have the discretion to determine whether or not to transfer that juvenile. And that's the important part of this legislation is that discretion lies with them to allow for any mitigating factors or to evaluate the circumstances of the situation and also the individual as a whole. Is that fair?
That is correct. Not only the judge, but the DA has to petition the court before that.
Leader Lamberth.
Move previous question.
Question's been called. Any objection? Seeing none, we're voting to send House Bill 2126 on the full criminal. Those in favor say aye.
Aye.
Those opposed? The ayes prevail. You move forward. All right, Representative Ritchie. Well, y'all don't even know what bill we're on yet. Hang tight, hang tight. Whatever, yeah. Item number 11. We're going to look at item number 11, Representative, House Bill 1925. All right, you're recognized.
Thank you, Chairman and Committee. This piece of legislation is extremely important, near and dear to so many Tennesseans across the state. Right now, the open field doctrine, how that ends up covering out, we've got law enforcement officers with TWRA that have there's a lawsuit that's currently pending along this particular arena. Me being an avid hunter, I don't know how many times I've had law enforcement officers come out to be able to check my license. There's no probable cause that I was out there actually hunting without a license. And that's what this particular bill would end up going to do, is to require TWRA to have a search warrant or probable cause along the post certifications. But due to the outstanding court case that's out there, we're expecting a ruling on that, which will give us judicial precedence on this right here. Chair, I would request that this be rolled to the last available calendar.
All right, without objection, we'll roll House Bill 1925 to the final calendar. We've got about 5 minutes left in the committee here. Representative, you've got item number 10, House Bill 1617. You're recognized.
Thank you, Chair and Committee. This particular piece of legislation extends from 10 years to 15 years, the period of time following the termination of active supervision on probation, parole, or any other alternatives to incarceration or discharge when it comes to the sexual offender or violent sexual offender registry with TBI. So it's simply just changing the time frame from a 10-year minimum to a 15-year minimum. Currently, based on the conviction, an individual is either at the 10-year minimum on there or they are at a lifetime. And this is just moving it from 10 years to 15 years so that we can encompass some of those situations to where we might have a 13-year-old victim involved, and we're extending it beyond 15 years so that those individuals are a little bit older.
And that is the effective date, July 1, all crimes committed and convicted after July 1 of 2024, this would be applicable to. Is that correct?
That is correct, Chair.
Okay.
There's no retro. It would only be for anybody convicted after July 1st.
All right. Thank you. Members, we do have someone here to testify, Ryan Davis. So we're going to go out of session. We're running out of time. I'm sorry. We'll give you the time to make your comments, and then we'll go back into session and probably have to adjourn until next week. So.
Thank you, Chairman. My name is Ryan Davis. On behalf of the Tennessee Association of Criminal Defense Lawyers and our 1,300 members, I'm pleased to address you all today. I'm an attorney. I'm a member of TACTL's Board of Directors and a resident of Williamson County. Despite the intentions behind this bill, this proposed change to our current registry law will actually decrease public safety. When our state's registry laws first came into existence roughly 30 years ago, we made a lot of assumptions about how our communities would be best kept safe from those who had been convicted of sexual offenses. But there is now a significant amount of data available that shows that despite the best of intentions, registry laws like Tennessee's not only are ineffective at reducing sexual offender recidivism, which is actually quite low despite popular belief, but these laws actually make our communities less safe. One of the most punitive aspects of the registry law that has proven to be counterproductive is the residential and workplace restrictions. Registrants are prohibited from residing, working, or even standing idly within 1,000 feet of any school, daycare, park, playground, etc. These restrictions are based on the myth of stranger danger and actually put children at greater risk of harm. Many victim advocate organizations publicly denounce residency restriction laws, describing them as irresponsible and counterproductive. By focusing on the stranger danger myth, we're taking the attention away from the much more likely assailant, which was a person that the victim knows. In a 2019 study, 87 to 96% of people arrested for sexual crimes were known by the victim. Rather than guiding the public to be more thoughtful of who they allow to be around their children, our registry laws send the message that children are safe as long as sex offenders can't access child-friendly areas. Additionally, unintended consequence of the location restrictions is that registrants are forced to move from urban cities like Knoxville and Nashville to more rural areas such as Maryville and such as Kingsport because they cannot find housing and employment in urban areas that is not located within one of those 1,000-foot restrictions. So the unintended consequence of bills like this and the extension and the perpetuation of our registry laws to an even longer period ensures that more and more registrants will be moving into the rural communities across our state. In defending numerous lawsuits over the last few years, the state of Tennessee has never once been able to demonstrate that the registry has ever accomplished what it set out to do 30 years ago, and that a single crime has ever been prevented because of the registry. In light of that fact, I would urge this committee to oppose House Bill 1617, which further extends the punitive and harmful effects of our state's registry laws. If the goal truly is no more victims, we must provide individuals who have successfully completed their punishment a reasonable opportunity to rehabilitate themselves. We heard earlier from Representative Faison about probation and parole. We need to give them an opportunity to actually rehabilitate themselves, secure employment, find stable housing, and lead productive lives. To do otherwise actually makes our community less safe, and this bill perpetuates that. So on behalf of the Tennessee Association of Criminal Defense Lawyers, I would graciously ask you to oppose this bill.
Well, thank you for being with us today and for your comments. Members, we will go back into session. I'm sure that you will have plenty of questions and concerns to express with the sponsor of this bill as we come forward, but you will have to hold those for the next 7 days. House Bill 1617 and all remaining bills left on the calendar not taken up today will be rolled to next week's calendar. We are adjourned.